If there was ever a time that you got to miss the SENZO MEYIWA trial, you are in luck because I break down what happened yesterday in Judge Ratha's courtroom in a matter of just under 30 minutes. Well, at least that's the goal I'm going to make because there's some things that are just so difficult to edit out. First of all, it seems like yesterday there was no need for an interpreter because he had absolutely nothing to say. Or should I say, he had no chance, zero, none at all, to even begin to disrupt the flow that was going on. Let me tell you, the courthouse was on fire. And when I say on fire, there were moments, several times, where Judge Ratha is seen scratching his head, okay? And you can just tell that the defense, aka Mnisi, Mshololo, and Nxumalo, okay, Zitulele Nxumalo. I just found that out yesterday that that's his name. And isn't that so ironic that he is a pure representation of his name? Okay, Uztulele Nxumalo. But you know what? Yesterday he said a lot, okay, from the bar. The defense was absolutely ambushed. They were only given an hour to prepare. Listen, Mnisi went all in, okay? Watch the clips that come ahead 53 times. Mnisi emphasized why the state's case is just hogwash. And he basically said, I am not sucking a thumb. Didn't Gomez not say that before? Nisi says, I am not sucking a thumb. This is stuff that the state brought to us. And now the state wants to tell us they want to bring back Stein? It is an absolute no. In fact, it's a hell no. In fact, you know what? You have dug your grave. The state is already 6 feet under. And if you insist on bringing Stein, you will just go deeper and deeper, okay? You will end up at 24 feet under. I mean, it is absolutely hilarious. And I'm just throwing you a few hints and tips of what happened there. The best thing is for you to listen to it yourself. Mshololo did not complete a cross examination. They ended up adjourning, okay, because the day had gone through. So, you know what? In this round, Mnisi carries the trophy. They all did an amazing job. But I have to say, Mnisi, with only an hour to prepare, was able to strike the state 56 times. And you know what? I make it really easy for you. Okay, I highlight every single moment. Please make sure you watch this video. Please watch the ads as well. And please remember to like, comment, and subscribe. I want to keep this video short, sweet, and simple. You know, I've added some animation throughout because I cannot believe what is going on in Judge Ratha's courthouse. But here's my thought. We'll find out in a few minutes anyway. But here's my thought. The defense did a phenomenal job threatening Ratha as well, basically telling him you have no grounds to approve the state's application. Okay, Nisi literally said there are no legal basis. It is flimsy, baseless. It has no legal basis. It will be unlawful, unjustifiable. Do you see what I mean? Like, and this is the part where Judge Ratha is just scratching his head because honestly, this is a tough one. This is a tough one. You're wondering why I'm not talking about Ungome Zulu and Uramasipili because they set this one out, okay? This doesn't affect, these 205s never affected their client in the first place, okay? And now all of a sudden there is other. How is, you know what? The state is really, really, really shocking me, okay? But Nxumalo as well says this will be unfair and no merit. Like they are using the words, they are telling Judge Ratha in advance, don't do it. Don't do it because we're already doing a fraud charge over there with Stein, okay? We're considering. But if you do this, you'll be doing yourself the greatest disservice of your legacy, of your reputation, just because Ubaloi is trying to do damage control, and we are not in the business of damage control here. The witness has already been called. That is it, okay? The reparation they can try and attempt to do is with Ukininda, because what? Stein did throw Ukininda under the bus. He did tell Umshololo during cross-examination last year, well, you better ask Gininda because he's the one who gave me all the stuff. So you know what? We got to wait for Gininda. We got to keep this train moving forward. You know what? I digress. But this, guys, you got to watch this. It is just phenomenal. Okay? Even if You got to watch some clips here and there yesterday. I've put it so well for you. Let me know your thoughts of it. Thanks for watching, and I'll catch you definitely later today.
However, I want to bring it to the attention of the court that as much as the court may be inclined in granting the state's application.
How do you know that?
My lord, I'm just making...
Yeah, but how do you know that? Otherwise, why should I listen to argument if I'm inclined to grant the application? I mean, it's simple.
My lord, that's what I'm saying in the event.
No.
In the event.
Are you saying I've prejudged this? Please, let's not make such allegations.
My lord, I'm not saying the court has already granted. I'm saying in the event that the court is inclined to grant the application by the state. Yes. My submission is that the constitutional right of the accused will be violated. Constitutional right of the accused to a fair trial will be violated by the granting of that application for the recalling of the witness, Colonel Steyn, on the following reasons, my lord, why it will be unfair.
That criminal charges will be contemplated. However, later, this was then put as follows, that a complaint will be contemplated against the compiler of the affidavit. Now, my lord, we submit that this is a very serious allegation that must be investigated. If there's a suggestion, as counsel put it, that there was impropriety on the part of Lieutenant Colonel Steyn, we submit, my lord, that it is incumbent upon the state to put those allegations to Colonel Steyn, and he be given the opportunity to comment on those allegations. We submit, my lord, that it is essential that Lieutenant Colonel Steyn be recalled in order to clarify these aspects so that the truth can be determined, and thereby enabling the court to arrive at a just decision on the case. And we submit, my lord, that there might be fail of justice if such explanation it's not considered. And, my lord, it pains the state if there's a suggestion that we would have put evidence that is improper before the court. And it is for this reason, my lord, that we want to put the matter beyond doubt. If the explanation is in favor of the accused, by all means. But the state, my lord, would like to the correct interpretation of his evidence to be put on record.
I do oppose the application.
Yeah.
Now, before I get to the reason why I am opposing the application, my lord, let me just clear certain issues that the court raised with the state when the state was addressing the court in this application. Now the court says, what I put to Mrs. Vittelingham seems to be bothering around the question of reputational damage. But that suggestion, my lord, and I'm saying this with due respect, seems not to take into account or lose sight of the fact that what I put to Mrs. Vittelingham was not something that I thumb-sucked. It was materially based on what the state presented as documents and on the analysis of the documents that were presented by the state. And a person with a background of a criminal justice system with that information would have done a disservice to the criminal justice system as well, not to have hinted that what was reflected in those papers actually does constitute fraud. Fraud being a misrepresentation of facts. After those facts were misrepresented, they were uttered, it means they were presented. It does not end up there, my lord.
Yeah, thanks, I'm with you. So, but the fraud then, is it uttered by Steyn or is it by Ms. Vallingham?
We are not yet at that stage, my lord. We are not yet at that stage. It is not for this court to determine who made that uttering.
No, I was in this court. Ms. Vallingham was reading, or was being cross-examined on the affidavit of Steyn.
Yes.
All I want to know was the alleged fraud directed at Steyn's affidavit or Ms. Vallingham's interpretation being cross-examined on Steyn's affidavit, or is it her own personal view and evidence under oath?
I think I made myself very clear, man.
Okay, fine.
That in an event that there are complaints that are going to be laid, and we're still contemplating that.
Yeah, fine.
That those complaints will be made by the compiler of that statement, which would have been Exhibit 01 in the circumstances.
And who's the compiler?
The document speaks for itself, my lord. I need not speak on behalf of the document. No, I'm saying the document speaks for itself.
Yeah, but I want to know, is it, who compiled the document?
The document, my lord, has been handed in as Exhibit O, as an affidavit.
Okay,
so at the inception, at the very first paragraph of that document, it indicates who the compiler of that affidavit is.
Who is that?
The document, as I say,
no, Mr. Mnisi, you're an officer of this court. When the court asks you a pertinent question, you've got to respond to it. Who is the compiler? That's all I want to know.
The document, according to this document, and that is not me saying that, according to this document, the affidavit was penned by Mr. Steyn.
Colonel Steyn, fine.
Yes. Let us on their good reputation. But this is not the case in this case. This is what the state produced, and this document has not been produced either by the defense. It comes from the state, my lord. And further on, my lord, I heard the court said that I said the basis of the complaint will be fraud, uttering, defeating the ends of justice, and blah blah blah. I can't recall saying blah 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 blah, my lord. I was very specific. I said fraud, uttering and defeating the ends of justice.
And forgery?
No, forgery. I never mentioned.
So they didn't forge the document.
No,
okay.
I never mentioned forgery.
Okay, fine.
Yes. Now, my lord, let me come to the reason why I say I oppose this application. Now, in the process of analyzing the evidence that the state has against those that it intended to indict before this court, the state must have come across this information, and that is not a reputational damage. The state must have had come across this information such that when they then started to present their evidence, it was then incumbent upon the state to bring it to the attention of Mr. Steyn, or even before Mr. Steyn comes and testify here, and or Mrs. Viti Lingam, during their consultation, if ever there was a consultation, and I do not insinuate that there was never a consultation, but a prosecutor, an ardent prosecutor, would have picked up this information even before the two witnesses come and testified here and took up these issues with them. And when they came to testify here, Mr. Steyn would then have been referred to this information and said, but Mr. Steyn, look, this is what Mrs. Viti Lingam says. I mean, this is what the affidavit of Mrs. Viti Lingam contains, and this is what your affidavit contains. What is a probable explanation for this discrepancy? Had the state done that, we would not have embarked on this exercise. Now, it is very late for the state to come now and say, no, we want to recall Mr. Steyn to come and address certain issues which came out when Mrs. Viti Lingam was cross-examined. Now, basically, all that the state is doing now is to do damage control, which is not a legal requirement for a recalling of a witness, my lord. The state did have an opportunity, on the basis of what I've just submitted, to take this aspect up with Mr. Steyn when he proffered his testimony there. For what reason why they did not do that, I don't know. Probably the state would come and explain that when he responds. And I can only hope, and sincerely so, my lord, that the state does not come up and say that is yet another reputational damage. My lord, it is a procedure unheard of. It is a procedure which turns our criminal justice system into a hollow of mockery. What the state is doing now is requesting this court to justify or to grant an application in its favor, an application that will turn this procedure, which has been so painstakingly laid in terms of more than 300 sections in terms of the Criminal Procedure Act, where the legislature sat it down and said, this is how we're going to regulate our criminal justice system. Now the state is requesting this court to simply overlook that in the interest of administration of justice. Administration of justice, my lord, does not mean that the standing rules of procedure and protocols and conventions, which have been applicable for so many years, should simply be overlooked in the name of administration of justice. So that phrase, administration of justice, encompasses or includes in its broader understanding and perspective a respect of the procedure that has been there for a very long time. As I'm saying, my lord, all that the state wants to do here, because of the embarrassment that has been abused in cross-examination of Mrs. Vaitilingam of what the state's case is all about, they're just simply in a process to do damage control. Now, as I'm saying, it is unheard of, my lord, to try and come and do damage control on an aspect of an evidence that came up when a particular witness was being cross-examined. That is best left for argument, because it is this court and this court alone, as a listener to the facts and the metric of the case, that is obligated to make a credibility finding. And also, my lord, let me just sound a word of warning to the state that the very same process that the state is now embarking upon might come and haunt them very terribly. They are in a grave now, which is 6 feet down. They are busy digging a grave that is going to take them 24 feet down. Because the reason why I'm saying this, my lord, is because ultimately the court will be called upon to make a credibility finding. Mr. Steyn would come and give a version that is different from the version that he gave initially. And I can tell you, my lord, that the state is going to find it very difficult, because we're going to have an opportunity to cross-examine him. The state is going to have a very difficult difficulty in trying to reverse all the little gains that the state has made thus far, my lord. I am saying, my lord, administration of justice does not permit a recalling of a witness to come and correct issues of contradiction that came out when a particular witness was cross-examined.
I thought Mr. Baloi said to come and clarify. Maybe I'm wrong, but as I'm sitting here listening, I thought the application is about the clarification, not the correction.
That's just
Okay, I'm just saying it. You can argue it further.
That has also never happened, my lord. Whether it's clarification,
okay, fine.
Whether it's clarification, whether it's correction, whether it's
not in our law.
It's an elongation. I've never said it's not in our law, man.
You say it has never happened.
It has never been heard of.
That's it. It means it has never happened.
For a party to recall a witness who he has an opportunity to lead in evidence in chief, who also had an opportunity to re-examine that witness after that witness was cross-examined, to have a third bite on the cherry.
Okay.
It's a very strange process indeed, my lord. Now the state has referred to this court, my lord, to some authority relating to the reopening of a state of a case by any party after the closure of both parties' case. Now the state wants this court to believe that the principle is applicable. No, the principle is not applicable, my lord. The cases that the state referred to this court, in fact, the cases that the state referred to this court to are utterly distinguishable from what is happening in here. Nobody has actually closed their case here. If the state actually wants to recall Mr. Steyn, it can only recall him for purposes of new evidence. And that would basically mean that the state has got to qualify the reason for the recalling of Mr. Steyn for that new evidence in terms of the passage that the state has actually read to the court. The reason why that new evidence was not read earlier on. But that authority is not applicable for purposes of recalling a witness in order to come and clarify, so to speak, by the state, issues that emanate from cross-examination. That is unheard of, my lord, which is the reason why I am saying the state, because it's rattled in one way or the other simply embarks on a process to do reputational damage, my lord. And the reason why, my lord, I say the state is embarking on a process to do reputational damage is not far-fetched. I mean, it is not a reputational damage, damage control. I'm sorry, damage control, not reputational damage, but damage control. And the reason why I'm saying that the state is embarking on a process to do damage control, my lord, the state itself accedes to that. Look at paragraph 1.13 of the state's heads of argument. They are basically conceding that this whole exercise is for purposes of damage control. And let me read what the state says in its own heads of argument, that they are conceding that we have been rattled to therefore want to do damage control, and this is what they say. An explanation by Lieutenant Colonel Steyn might foreclose. That term foreclose simply means to rule out or prevent the request of accused number 3 that charges be laid against the compiler of the information, saving the scarce state resources. Who said the state has got scarce resources? Who said that? Particularly in the context of a quest where this accused person, upon being convicted, they potentially facing a term of life imprisonment, and we are being told by the state that we need to save the scarce state resources by limiting the rights that is by limiting the right to a fair trial that these accused persons are having. That is very unfair, my lord. This is just a demonstration that this whole exercise is nothing else but an endeavor by the state to do damage control. On paragraph 1.4 of the state's heads of argument, this is what the state says from line number 5. Thereafter, it was put to her, that is now, I think, Mrs. Vittilingam, that accused number 3 has given instructions for criminal charges or complaint to be laid against the compiler of the affidavit. This is a very serious allegation that must be investigated. The allegation ought to be put to Lieutenant Colonel Steyn and be given the opportunity to comment. What procedure really underpins that, my lord? Because this information emanated from cross-examination. And I've already said that this should have been picked up by the state during the preparation of this case, that there is this discrepancy here, so that Mr. Steyn, when he came here and testify, he should also allude to this. But nonetheless, my lord, I haven't heard of any suggestion such as this one, that when a person who wants or when a person wants to go and lay charges against a particular person, then they need to go to him first and say, this is what we're going to do. So you therefore need to therefore, you ought to have a comment or to answer to this allegation. That's not the duty of the complainant. Once a complainant identifies that a wrong has been done, there is nothing that prevents him to go direct to the law enforcement agencies to go and lay a complaint against the person who or she thinks that is on the wrong side of the law. And it will be for that forum, subsequent to the laying of that complaint, that will have to go and determine all the aspects and the dynamics of that complaint. So the state basically says that we ought, in other words, we must, as a basis of this application, that Steyn must be recalled, that we must come and tell Steyn that Steyn, we, amongst others, we consider, I think you'll be standing there, Steyn, amongst others, we are considering to go and lay charges against you, and the basis of those charges are going to be fraud, uttering and defeating the ends of justice. That's just a hogwash, my lord. Ultimately, my lord, let me say that this exercise that this state wants the court to embark upon is nothing else but to remove this embarrassment that is on their table, which is based on the discrepancies which have been identified when Mrs. Vittilingam came and testified here. She was also at pains to say, I smell a rat, and a very rotten rat, because of, I don't know, because of what reasons. But everybody could see that she was at pains at that meeting that there was indeed a fraud here. I would therefore request, my lord, that there are no legal basis, that this application by the state is baseless. It's flimsy. It has got no legal basis. It will be procedurally incorrect. It will be unlawful. It will be unreasonable. It will be unjustifiable, no matter how much amount of reasoning there might be for it that this application should be granted. There are no basis. I therefore request, my Lord, despite the fact that the court has indicated more than once that it is averse in granting this application, but nonetheless, I still submit that it should not be granted. Thank you, my Lord.
My Lord, firstly, I must state that I'll be making my submissions from the bar. I did not get an opportunity to prepare my heads of arguments.
No, fine.
By this, the suggestion that has been made by the state for everyone to see is that accused number 5 and Ms. Kelly Nxumalo are the masterminders who were masterminding the commission of this offense. To an extent that accused number 5, Mr. Nduli, he procured the services of the other accused in the commission of the murder. What then brings this into sharp focus, my Lord, is the affidavit of Ms. Pinky Vitilinga, which came up with a totally different picture about the other party that I've referred to earlier. The other party which is contained in the affidavit of Lieutenant Colonel Steyn. Maybe to stretch this again, my Lord, I wish to refer the court to page 34 of the affidavit of Lieutenant Colonel Steyn. Lieutenant Colonel Steyn, my Lord, attributes in the layman's term the number 278345713330. That is the number which made a call to Ms. Kelly Nxumalo on the 2nd of August 2014 as at 2200 hours 40 minutes 47 seconds as the number belonging to or attributable to Mr. Arthur Mofokate. So in layman's term or in simple terms, it means that on the 2nd of August 2014 at 2200 hours 40 minutes 47 seconds, Mr. Mofokate made a call to Ms. Kelly Nxumalo and not accused number 5 as it was detailed in the affidavit of Lieutenant Colonel Steyn. On the 15th of October 2014 at 1700 hours 33 minutes 57 seconds, Ms. Pinky Vitilinga considered that the number 27714379551, that was the number which belonged to the deceased, which made a call to Ms. Kelly Nxumalo on the 15th of October 2014. As I've indicated, my Lord, that the two transactions are what brings this application into sharp focus. And it raises an attempt by the state to bring the administration of justice into disrepute. In the sense that the evidence is on record, there is no need for the state to recall Colonel Steyn. The state and the defense can argue on these issues and for the court to adjudicate on in its own judgment at the end or at the closure of the case for the state and the defense. I also wish to re-emphasize the submission which had been made by my colleague, Advocate Mnisi, that from the beginning, when the indictment was drafted, the state was supposed to be in possession of all the documents. That is the Section 205 records. In order for the state to make an informed decision, other than when we are faced with this situation, a witness has to be recalled in order to testify. That is the danger, my Lord, of the piecemeal approach in the presentation of the state case and in the manner in which the state has provided the further particulars, day in, day out, further particulars being provided to the defense. The provisions of Section 35, subsection 3 of the Constitution. One is attempted to mention the provisions of Section 35(3), subsection small letter b in bracket and I in bracket of the Constitution, which provides the following, and I quote, Every accused person has a right to a fair trial, which includes the right, small letter B in bracket, to have adequate time and facilities to prepare for a defense. Small letter I in bracket, to adduce and challenge evidence. Sorry, my God, may I just go through the provisions of the Constitution verbatim. Small letter I in brackets, that is section 35, subsection 3, small letter I in bracket. Every accused person has a right to a fair trial, which includes the right to adduce and challenge evidence. The court is well aware, my Lord, that we have gone past the stage. The accused have, through their defense counsel, obviously cross-examined the witness, Colonel Steyn, and proffered a defense. I submit, my Lord, that when one has to go through the very same exercise of cross-examining the witness, in the instance where the witness had initially been cross-examined by the defense, that will bring the whole exercise into disrepute. It is my submission further, my Lord, that the recalling of Colonel Steyn will render the whole trial unfair and detrimental to the accused person. The application by the defense, by the state, I submit, it is a devoid application which has no merit. I will then, my Lord, go through the paragraphs of the state's heads of argument with an attempt to reply thereon. My Lord, I must mention that whenever Colonel Steyn was asked about the Section 205 records, he will tell or respond in a manner that suggests that he received the Section 205 records from the investigation team, and he will not proffer any explanation about how such Section 205 records was procured. I must mention in this regard, my Lord, that Brigadier Kininda has still to be called to testify in this regard. And he is a person to clarify this. That is the record that Lieutenant Colonel Steyn worked on the 9th of April 2020, as he says he received the Section 205 records from the investigation officer, Brigadier Kininda. It is my submission, my Lord, that the application by the state is devoid of any substance and it tends to be dismissed. That is all, my Lord. Thank you.
Okay.